Senate Judiciary gave Dick Durbin 5 minutes, and he used them to put two writings by a judicial nominee side by side: a public letter to Columbia's president committing not to hire from the 2024 class, and a recusal order writing that he held no bias toward Columbia students. Then he asked the nominee one simple question: how can both statements be true at the same time? The nominee said the letter targeted administration conduct, not students. So watch it unfold for yourself, and our research team will break down the full analysis at the end.
Chair Britt, thank you, Judge Traynor, for being with us, and thank you to your family and friends for showing their support. Judge, you were a contributing author and signatory of a letter to Columbia University criticizing the university's response to protests on campus following Hamas' October 7th attack on Israel. In that letter, you vowed not to hire anyone who joins the Columbia University community, beginning with the entering class of 2024. Yet, in denying a recusal motion in Thunderhawk versus County of Morton, which was brought by the Columbia Law School Initiative for a Just Society, you said, quote, "I reaffirm my lack of bias toward any student or Columbia faculty or initiatives of its law school." With all due respect, Judge, this statement seems contradictory, stating at one point that you would not hire anyone from Columbia, and second, that you have no bias against those from Columbia. Can you explain?
Senator, the letter was targeted and directed to the president of Columbia University. And the reason why is because there were Jewish students who had enrolled in the educational system at Columbia and were having to shelter in place. The administration, some of the professors, were engaging in the conduct of trespassing, violent conduct, and making these students feel that they could not obtain an education. I'm a former member of the North Dakota Board of Higher Education. It is important that when students are able to be educated, that they have the opportunity to pursue that education. That type of conduct was not being appropriately handled, and it was, as described in the letter, a cauldron of bias that was being promoted on that campus. And so that's why I signed on to the letter.
You've explained why you signed the letter. Can you explain why you reversed your position?
Senator, I don't believe that I reversed my position. What I stated in the recusal order with regard to an application from some, I believe they were graduates of Columbia, that I don't hold a bias against graduates of Columbia. I don't hold a bias against people who attend the institution. The purpose of the letter was to do what the little one can do as a federal judge.
So you're saying you wouldn't hire them because they're from Columbia and this conduct, and then saying you have no bias against Columbia. I don't follow that.
Senator, these lawyers had graduated from Columbia long ago. They were in practice, and as a result, the boycott of the letter that I signed on to did not apply to them.
I'm not a graduate of Columbia, but I'm still troubled trying to understand your logic. You volunteered to hear habeas petitions from immigrants who were rounded up as part of Operation Metro Surge, the notorious ICE action in Minneapolis that led to the deaths of 2 innocent individuals. Around the country, the Trump administration has detained tens of thousands of immigrants, 85% of them without any criminal records. Overwhelmingly, district court judges appointed by both Republicans and Democrats have held that mandatory detention is illegal and unconstitutional. According to Politico's analysis, judges have ruled against the Trump administration's policy of mandatory detention more than 10,000 times. And even a majority of Trump-appointed judges have ruled against the administration's position. You are an extreme outlier on this issue, which you've even acknowledged in several of your opinions. In your opinions, you embrace the Trump position that it can detain any immigrant without a bond hearing, no matter how long they've been in the United States, and even if they have no criminal history. Why did you volunteer to preside over these cases in Minnesota? And in light of your embrace of the Trump administration's position, even when judges have ruled against the administration policy more than 10,000 times, Why should we feel or have confidence you can be a neutral arbiter when it comes to presiding over challenges to the Trump administration action?
Senator, I volunteered to help in Minnesota because I was previously licensed in Minnesota. I was previously assigned to handle a case and actually conducted a trial in the District of Minnesota. And when North Dakota was down to one federal district judge, judges from throughout the country, including many from Minnesota, were very helpful in handling matters that were pending in the District of North Dakota. And so that's why I signed up.
But the bottom line on the issue of habeas corpus, the issue of detention, why is it you're such an outlier when it comes to Trump policy?
Senator, I reviewed the law. I felt that the administration was acting within their limits, and I made my decision. I based it on the law, and I also based it upon what I expected the Eighth Circuit Court of Appeals would do. And indeed, the position that I took and the ruling that I made was upheld by the Eighth Circuit.
What made this exchange land was the patience of the construction. Senator Dick Durbin did not raise his voice. He walked the judicial nominee step by step through one written commitment and one written ruling. The commitment, in a public letter, was that the nominee would not hire law clerks from the Columbia graduating class beginning in 2024. The ruling, in a denial of a recusal motion in Thunderhawk versus County of Morton, was that the nominee held no bias toward any Columbia student or faculty member. Durbin asked the obvious question, how can both of those statements be true at the same time? Set the predicate. The nominee, along with several other sitting federal judges, signed an open letter to the president of Columbia University. The letter committed the signatories to not hiring anyone who joined the Columbia community starting with the entering class of 2024. Whatever the merits of the underlying concerns the signatories raised about campus protests and Jewish students having to shelter in place, the letter is an unambiguous, on the record written declaration that a specific institutional affiliation would be a disqualifying factor for clerkship hiring. That is the public commitment Durbin asked about. The other side of the contradiction Durbin developed is a recusal order the nominee wrote in Thunderhawk versus County of Morton, a case brought by the Columbia Law School Initiative for a Just Society. In denying a recusal motion in that case, the nominee wrote that he reaffirmed his lack of bias toward any student, any faculty member, or any initiative of the Columbia Law School. That ruling is the formal judicial position. It is the on-the-record statement of the nominee's stance toward Columbia in his capacity as a judge. Durbin's question was the obvious one: how can these two writings coexist? The structural contradiction is straightforward. A judge cannot publicly commit to not hire any Columbia student starting from a specific cohort, in writing, signed to a letter addressed to the institution's president, and also simultaneously claim to hold no bias toward Columbia students for purposes of judicial determinations. Either the hiring commitment reflects an institutional view that should be acknowledged in adjudication, or the no bias claim is true, in which case the public commitment is harder to justify. Durbin did not need to rhetorically attack the nominee. The two writings, side by side, did the work. The nominee's defense was that the letter was targeted at the president of Columbia University, and at the institution's administration specifically, not at the students. He referenced concerns about Jewish students who had to shelter in place during campus protests, and about administrators and faculty who he said had engaged in trespass and violent conduct. The letter, as he framed it, was meant as a federal judge's small public stance against what the letter described as a cauldron of bias on campus. The defense locates the action against the institution's leadership rather than its student body. It is a real distinction. Why Durbin could not reconcile the framing is that the operational effect of the letter falls directly on individual students. The letter does not refuse to do business with the president of Columbia. It refuses to hire individual law school graduates from the 2024 class onward. Those individual graduates did not run the administration. They did not engage in the conduct the letter described. The targeted message, in its actual mechanism, lands on students who had no role in the actions the signatories were objecting to. That gap between framing and effect is what Durbin pressed. The nominee then offered a narrower carve-out. The recusal order in Thunderhawk involved lawyers who had graduated from Columbia long before the relevant protest period and were already in practice. Those graduates, the nominee explained, were not covered by the hiring commitment in the letter, which was specifically about the entering class of 2024 and forward. So the no bias declaration was about the specific graduates in front of him, not a blanket statement about all Columbia affiliates. Durbin acknowledged the carve-out and said he still could not follow the logic, which is the exchange we then heard. Why the carve-out is still uncomfortable is institutional. The public commitment exists in writing. It is not retracted. It was not narrowed in writing. Anyone who reads the letter understands the commitment to apply to the entering class of 2024 and the cohorts after it. The recusal posture in Thunderhawk applies the doctrine narrowly to the specific facts of that case. But future cases that involve the 2024 cohort or later will land in front of a judge whose public commitment is on the record. The Thunderhawk parse will not automatically cover them. That is the open ambiguity Durbin highlighted. With the Columbia exchange on the record, Durbin pivoted to a second issue. He noted that the nominee had volunteered to hear habeas petitions from individuals detained under what was described as Operation Metro Surge, a federal immigration enforcement action in Minneapolis. The volunteering matters as background. District judges do not usually volunteer for specific case categories. A nominee who has volunteered for a particular type of case is signaling something about their interest in that area of the law. Durbin treated the signal as relevant, so would any senior senator on Judiciary. Durbin then laid out the numbers. Across the country, the administration had detained tens of thousands of immigrants. Roughly 85% of those detained had no criminal records. That is the foundational statistic on the mandatory detention question. It is not a statistic that an opponent of the administration constructed for political purposes. It is the population of people being held under the policy. Durbin used the number as the entry point for what he wanted to get on the record, about how the nominee's rulings compare to the broader judicial reaction. Durbin then identified the relevant comparison. District court judges appointed by Republican and Democratic presidents alike have held that the mandatory detention practice at issue is unlawful and unconstitutional. That bipartisan pushback is the load-bearing fact. It means the legal question is not a partisan question. It is a constitutional question that judges across the political spectrum have answered the same way after reading the same statute, the same case law, and the same constitution. Durbin used that comparison to locate where the nominee's rulings sit relative to the broader bench. Durbin cited the Politico analysis. According to that count, judges have ruled against the administration's mandatory detention policy more than 10,000 times. That number is large. It is also concrete. It tells the public and the committee that the legal question has been litigated extensively and consistently across courthouses. A judge can certainly disagree with that broader trend on principled legal grounds. What a judge cannot easily do is be unaware of the trend. Durbin's reference to the count was not rhetorical. It was an empirical reference point against which to evaluate the nominee's record. Durbin added the most important refinement. According to his presentation, a majority of judges appointed by the current administration have also ruled against the administration's mandatory detention position. That fact removes any easy partisan explanation for the broader trend. Judges appointed by the same president who initiated the policy have looked at the underlying law and ruled against the policy. That is the load-bearing fact for the outlier framing Durbin then deployed. If even the president's own appointees are not following the administration's position, a nominee who does follow it is, by definition, outside the consensus of the courts they would join. With the numbers on the record, Durbin used the term outlier. He called the nominee an extreme outlier on the mandatory detention question. The framing is precise. It does not say the nominee is wrong. It says the nominee's position is, statistically, far from the center of the bench's reasoning on the question. The nominee acknowledged this in some of his own opinions, by Durbin's account. That acknowledgement matters because it shows the nominee is aware of where his rulings sit relative to the rest of the courts. The outlier framing is supported by the nominee's own writing, which makes it harder to dismiss. Step back to the volunteering point. District judges do not have to volunteer for any specific class of case. The multi-district litigation panel handles broader assignments. Routine docketing handles most case allocation. A judge who actively volunteers to hear habeas petitions from a specific federal enforcement action is making a choice. That choice is appropriate when the judge believes they can offer particular care or expertise. It is harder to defend when the judge's record on that area of law sits outside the consensus of their colleagues. Durbin used the volunteering point to anchor the larger pattern he was identifying. Worth restating the stakes. Habeas corpus is, by design, the last protection a person has against being held by the government without lawful authority. It is a constitutional remedy. It is what a person who believes they are being held without proper process can use to ask a federal judge to test the legality of the detention. A judge who hears habeas petitions is exercising one of the most consequential powers a district judge holds. The standard the judge applies in those cases determines whether the constitutional protection works as designed. The nominee's record on that standard is therefore the right thing to scrutinize at confirmation. Durbin did not state his ultimate conclusion. He let the pattern speak. A nominee who publicly committed not to hire from Columbia after a specific cohort. A nominee whose rulings on mandatory detention sit outside the consensus of both bipartisan appointees and the current administration's own appointees. A nominee who volunteered to hear habeas petitions from a specific high-profile immigration enforcement action. Each fact in isolation is defensible. Taken together, they form a pattern the senator clearly wanted committee members to weigh. Whether the pattern is dispositive is for the senators to decide. Durbin made sure the pattern was on the record. Give both sides their due. Durbin built the pattern carefully and named each component without theatrics. The nominee defended each piece on its own terms. The Columbia letter was directed at the administration, not students. The Thunderhawk recusal order applied to specific past graduates. The volunteer habeas role reflected interest in an area of law that needed careful district judge attention. The mandatory detention rulings reflected his reading of the relevant law, even if his reading differs from many colleagues. Neither side flinched. The committee record reflects both. That is the format working properly. This Durbin exchange will be cited well beyond this hearing. Future Judiciary Committee staff will reference it as a template for how to put two contradictory writings of a nominee side by side and let the contradiction speak for itself. Bar associations and law schools writing on judicial ethics will likely use it as a teaching moment. Advocacy organizations on both sides of the immigration question will draw on the numbers Durbin presented. The hearing transcript is now part of the permanent record of how this nominee's confirmation was evaluated. Senators on both sides of the aisle understand this and have written their participation accordingly. So the final accountability question is the standard one. What was gained, what was lost, and who is paying the cost? If the contradictions and the outlier pattern Durbin developed weigh heavily with the committee, the confirmation calculus shifts and other nominees will calibrate accordingly. If the pattern is set aside in favor of the nominee's individual defenses on each piece, then the practice of public letters and outlier rulings becomes more sustainable across the federal bench. Either outcome carries downstream consequences for litigants, for the bench, and for the canons of judicial conduct. The committee's vote and the floor vote that follows will calibrate the next round of nominee behavior. The public can decide what kind of standard it is willing to vote for.